On the applications of Kiarie and Byndloss versus the Secretary of State for the Home Department.
Lord Wilson will explain the judgment of the court.
Mr. Kiarie, the first appellant, is a Kenyan citizen and has lived in the UK since 1997. Mr. Byndloss, the second appellant, is a Jamaican citizen and has lived in the UK since 2002. Each of them was convicted in the UK of drug-related offences and was sentenced to imprisonment for more than a year. This means that they each fall within the definition of a foreign criminal contained in the UK Borders Act 2007. Prior to the release of the appellants from prison, the Home Secretary made deportation orders against them. She rejected their claims that deportation would breach their human right to respect for their private and family life in the UK under Article 8 of the European Convention. On this point, however, they have a right of appeal to a tribunal. The Home Secretary did not certify that their human rights claims were clearly unfounded. She therefore conceded that they were, at any rate, arguable. But in each case, she issued a different certificate, which is the subject of the appeals to this court. These were certificates under Section 94B of the Nationality, Immigration and Asylum Act 2002. In relation to a foreign criminal who was making a human rights claim, this section, which came into force in July 2014, entitled the Home Secretary to certify that removal of him prior to his appeal would not breach his human rights. The effect of the Home Secretary's certificates is that the appellants can't bring their appeals before the tribunal until after they have been deported to Kenya and Jamaica. They challenged the lawfulness of the certificates. In the Court of Appeal, their challenge failed. It's therefore important to note that these appeals are not about the circumstances in which a foreign criminal can escape deportation by reference to his private or family life in the UK. We recently addressed that question in the case of Ali against the Home Secretary and ruled that the circumstances would need to be very compelling before he could do so. It may therefore prove difficult for these appellants to win their appeals, but that's not the point. The point is whether, in circumstances in which they each have a right to bring an appeal, indeed an appeal which is arguable, it would be a breach of their human rights for them to be deported in advance of it. This court allows their appeals. It holds that the Home Secretary's certificates are unlawful, and it quashes them. The decision is unanimous, but Lord Carnwath adopts grounds which are narrower than those adopted by the rest of us. Our reasoning is as follows. 1, the right of the appellants to appeal to the tribunal must be an effective right. 2, their appeals, which are profoundly important to them, will not be easy. 3, they must be in a reasonable position to assemble their evidence and present their arguments, in particular about the level of their integration in the UK and the quality of their relationships with others living here, and presumably also about why they are unlikely to reoffend. 4, although they might possibly be able to secure representation or other assistance in relation to their appeals, it is at least as likely that they will have to conduct them entirely on their own. 5, the collection of evidence, perhaps including expert evidence, from abroad is problematical. 6, without the facility for the appellants to give oral evidence to the tribunal and otherwise to participate in the hearing, their appeals will stand almost no chance of success. 7. Evidence from abroad by video link or Skype, though less satisfactory than evidence in person at the hearing, might well suffice to make their appeals effective. But the facility to give evidence from abroad on screen, and also in that way to participate generally in the hearing, is at present not realistically available to the appellants. Although the tribunal would presumably permit them to give evidence on screen, it would require them to pay for the facility to be set up not only at the foreign end, but also at the hearing centre itself. The costs are large and way beyond their resources, and the logistics are complex. 8. Statistics show that when foreign criminals have been deported in advance of their appeals, they have seldom even filed notices of appeal, and that when they have done so, their appeals have, to date, invariably failed. The majority concludes that the Home Secretary has issued the 2 certificates in the absence of a system for the effective conduct of appeals from abroad. Their effect would be substantially to obstruct presentation of the appeals. That's why they're unlawful.
Thank you very much. Very well, the court is adjourned.